Welcome to the Supported Living Property Podcast with your host, me, Lisa Brown, the place to learn about supported living property investing. Hi Christine, it's great to have you here today. Thank you for joining me. How are you?
I'm fine, thanks Lisa, really well. Thanks for inviting me.
Good, it's great to have you here. For those who don't know you, Christine, do you want to introduce yourself and tell people a bit about you?
Yeah, sure. I'll keep it as short as I can because I've had a long career because I'm so old now. Okay, so my name first, Christine Janaway. I'm a fellow of the RICS, that's the Royal Institution of Chartered Surveyors. I qualified way back in the olden days of 1989. Gosh, that's so long ago. And all my career, basically, I've dealt with leases. I mean, some surveyors do like resi valuation, mortgage valuations, all that type of thing, or they might go on to be building surveyors, quantity surveyors, or whatever. But my career has always really been about leases, either for operators or occupiers. I've been head of property at 2 national chains of estate agencies. I've been a partner in charge of a fee-earning commercial surveying team. I've done structured finance, I've done development, I've done all sorts of random, actually, bits and pieces. Some people might say I've got very broad experience. Other people might say I just duck and dive around from one thing to another. I prefer the former, obviously.
I think definitely broad experience.
So what I'm doing at the moment is I own a lettings and management agency in the North Cotswolds. We do holiday lets and normal buy-to-lets, so a bit of a plug for my business there. But as an investor, I've moved more and more over to the social housing sort of focus for lots of reasons, which we don't have time to go into now. But that is primarily my focus now. I've still got some buy-to-lets and commercial and stuff, but the thing I'm really focusing on is social housing, supported care, living, that type of thing.
Perfect. That's great. And I think the main question I wanted to ask you was about why a lease and not an AST? Commonly, when I'm talking to people, they kind of think, oh, I can just use an AST. I don't need a lease. And so that's what I wanted to kind of pick your brains and go over with you today.
Yeah, sure, no problem at all. Okay, so an AST is a very specific thing, Housing Act 1988 thing. It is a right to occupy by an individual or group of individuals, family or whatever, and they actually need to be in occupation, and they are individuals themselves. So Mr. and Mrs. Fred Bloggs and their 16 children, they're the people who are going to occupy, and it's governed by over 170 pieces of legislation, that relationship. And you can grant an AST very easily, verbally. It doesn't even have to be in writing. There are certain clauses which will automatically be read into even a verbal agreement. But the one time you cannot, well, there's two occasions you can't use an AST. First is if you are a living landlord. So if it's a lodger, it's your own home, you have a lodger. You can't use an AST then, you need a lodger agreement for your own security as much as anything else, because they won't be protected by the 88 Act. And the other instance is where you are not letting, either you're not letting to an individual, it's a company or some sort of organisation, or you can be letting to an individual, but they're not actually going to be living in it themselves. So you could take, in the supported living arena, a 5-bed house. You could grant a tenancy, let's call it that for the moment. So a tenancy can be an AST or it can be a commercial lease. So you can grant a tenancy to Fred Bloggs, to use that name, but unless he's in occupation himself, it is not an AST. If other people are going to occupy, Mr. Bloggs will be granting the ASTs maybe to those individuals in occupation, but he himself cannot have an AST. Now, if you actually have already signed an AST with him, the normal legal processes come into play. If there's ever any dispute, the judge will look at that document and say, well, I know it says it's an AST, but it's not an AST, it's a lease, commercial lease effectively, because they're not in occupation. And similarly, if you were to grant a lease to an individual who would then live in that property themselves, and there was any dispute, the judge would look at that and say, I don't care what it says on this. This is an AST, and that's how I'm going to treat it. So you can have a piece of paper that says all sorts of things, and people sometimes use licenses, don't they, particularly for agents. And the document is called a license, and it's got all sorts of terms in about this and the other. Completely irrelevant legally. That is an AST, and all the normal protections apply. So that's the basic difference, which I hope is reasonably clear.
Yeah, that makes sense. So even if you've granted the wrong thing, for the courts would treat it. Yeah,
absolutely, as what it actually is, not as what it calls itself. You know, if it's the old sort of chestnut, you know, if it waddles and quacks, then it's a duck. It doesn't matter if it goes, oh, I'm a swan, it's still a duck.
So from most of our property investors would be letting properties to organizations, whether that's a care company, a charity, a housing association. So that would mean they have to, it's a lease that they need to be using.
It's a lease, yeah. And I know that various organizations supply documents that they call company-let agreements. And you know, for some circumstances, they're probably adequate. But for me, they just don't have the breadth and depth of the detail that's really needed to manage your relationship with the organisation who is going to be your tenant, and how they're then going to deal with their relationship with the people actually in occupation. For me, a company-let agreement was a little bit thin. I mean, I'm used to commercial leases, okay, with institutions and all sorts. So, you know, a typical commercial lease that I might deal with daily might be 50, 60 pages long. They don't need to be that complicated, but they do need to be detailed enough so that all parties know exactly what they're dealing with. And in particular, if you want to exclude them from security of the Landlord and Tenant Act 1954, they really need to be a lease. And you need to go through the correct process to make sure they are excluded. And there's different processes depending on how long a gap between agreeing the words and actually signing it. 14-day gap. Sometimes you have to serve a notice, sometimes you can just put it in the document itself. It used to be that you had to go to court and get the court to rubber stamp it being outside the act. But I think whoever amended that legislation must have realised that actually most people are grown-ups when they're entering into these documents, and they should jolly well know, you know, what they're letting themselves in for. Because there are, if a lease is excluded from the 54 Act, there are only a couple of circumstances in which the landlord can refuse a new lease when that one expires. But that's a lot of detail we don't want to get in here today. Yeah, so that's the basic. I would always want to see a lease with sufficient amount of detail in it, rather than just a 3-page company-let agreement that you've downloaded off the internet from somewhere.
Because it's a serious document, isn't it? And I think that's the thing. Sometimes people don't treat them with the kind of gravitas that they need. I mean, they scare me, quite frankly. I would always get them read by someone who knows what they're talking about, because I wouldn't pretend to. So, you know, and who would you be thinking should be giving you that advice? When, you know, who should you be?
Well, various people can prepare a draft document. I mean, I do them, for example, and they are normally, if you were going to take a lease on a premises that's not an AST, so that would normally be a shop, an office, you know, a factory, but can equally be a house if it's for these purposes. You would have someone acting for you, and they would draw up a heads of terms which covers all the pertinent terms that you've agreed, and then you would hand that to your solicitor and say, can you turn this into a lease, please? But it's perfectly possible to have a draft template lease which covers all the relevant points, and then you insert the detail. So it's, if you like, it's sort of a glorified heads of terms, vastly expanded. So the terms you're looking to put in there, which are really important, are first of all who you are and who the tenant is, very important, and whether you've got a guarantor, because they need to be what's called a surety on the lease. and they will have certain obligations if the tenant fails to do X, Y, or Z. And then you're going to have how long the lease is for, and then you're going to have how much rent they're going to pay on day one, or if there's a rent-free period on day whenever the rent starts, whether there's any other contributions they have to make to, if it's a short lease, 3 or 5 years, you shouldn't get anyone signing up to a full repairing lease on that basis. There would be responsibilities for the landlord. So whether the tenant contributes to those or not, which is a service charge effectively. Who pays for the insurance? Is it shared? Is it just the landlord? Is it just the tenant? If the rent's going to increase during it's called the term of the lease. It's really confusing because you see a lease and it's got lease terms, and then it says term of the lease. You think, well, that's a bit weird. But lease terms are just the clauses in the lease, and the term of the lease is the length of the lease. Surveyor speak. It's confusing. I don't know if it's deliberate. Probably, actually.
It always feels like it is.
It's to keep everybody out, you see, keep it a little closed shop. That's what it is. So whether there's going to be any rent reviews during the term of the lease, the length of the lease, if so, when are they going to be? How are they going to be calculated? Is that by RPI? Is it going to be a set increase? It's going to relate to the local housing allowance or any sort of other grant income, or the council, maybe if they're sponsoring the occupier and things like that. Then you're going to have the repairing covenants. And the shorter the lease, the more important these are, because every term of a lease directly impacts on the amount of rent you're going to get as a landlord. Okay, so if you make the lease very onerous, you're effectively reducing the market demand for that property, for that lease, and therefore the price will be, depressed. Like, it's just simple economics. So if you make things very onerous, the repairing covenant, the user clause, what they can use the premises for, severely restricting the types of occupiers they can have in there. If you add in things like vacant possession yielding up clauses, which is a whole other can of worms, then you're going to suppress the amount of rent that you're going to receive on that lease. Because whereas you may have a potential pool of 30 possible organisations wanting to take that property from you, if you make it too onerous, you might just be down to 1 or 2. So as with any other commercial arrangement, the smaller your target pool of buyers, the less the value. Basically, that's how it works.
I suppose most of these transactions we're talking about for the people listening to this might be residential properties or small blocks of flats. So there would normally be residential ASTs on them. So therefore, they're then altering them from their point of view to put a commercial lease on them. That's where so they may want to restrict the kind of tenants that are in the property as well. And
if they've got mortgage, whoever their lender is may want to restrict. I know some mortgage lenders, because obviously you've got to also make sure you've got the right type of mortgage in place. That's another big thing.
Yeah, we've had several sessions on that one. That's so important. Yeah.
And the lender themselves, pick your lender according to your occupier, because some of them I know don't like asylum seekers, for example. Some of them won't take homeless, transitioning into permanent accommodation. They will have their own rules based on their own risk underwriting. So it's a bit of a circle, because you've got your property and then you've got your potential leaseholder, which would be the organisation, and their clients, and then you've got your lender, and you've got to try and make sure that they all dovetail into each other and there's no clashes and difficulties.
Absolutely.
I mean, the last thing you want to do is for someone to notify your lender that you've got asylum seekers in your property and it's actually against the terms of your mortgage, because they will not hesitate to call it in.
Yeah.
And then you're scrabbling for a new lender. Nightmare.
Yeah, absolutely. It's a horrible situation to be in. The other thing that comes up frequently in those discussions about heads of terms is break clauses, isn't it? That's always something that people...
Yeah, absolutely. So it's entirely a negotiated thing, a break clause. Although, having said that, if you if you've got a reasonable sized property, say you've got a block of 20 flats and a fairly sizable operator wants to take a lease of them, they've probably got their own standard lease. And the reason for that is that they have to asset management these properties in-house. And they'll want to know that every single one of their leases is identical. So, and they may have a policy, in fact, about having a break clause at year 3, 5, whatever it is. And they'll probably also want to have what they call an Armageddon clause in there, which is exactly like it sounds. If Armageddon happens, they're going to tear the lease up. So if something, it'll be set out in the lease what the circumstances are, but say they lose their regulatory status, or they lose their Care Quality Commission, stamp of approval, or the local authority stops funding their clients and they literally cannot carry on. I mean, it's unlikely, but it does happen. Then they'll be able to just say, okay, we're breaking the lease right now. So it won't be at a normal break date. It'll just be maybe on a month's notice. The lease is gone. You would hope that they'd come and talk to you before then, because you've still got people living in there. The fact they've stepped away, but they're not taking the people with them necessarily. They might still be living there. Now, if the local authority is still sponsoring them or you have a nomination agreement, then they might assist, they should assist in finding a new operator and therefore someone else to take the lease. And that's why it's important to have a surety, because one of the obligations will be that if the leaseholder, Care Homes number 1 or whatever, I hope that's not a real company, but you know what I mean, Care Homes Mr. Blogs number 1, exercises the Armageddon clause, you would want the surety to undertake to pick up a lease in their stead. That's how I would want to see it. Whether they would be willing to do that is a different matter. These are all negotiated terms. There are very few statutory terms in a commercial lease. Basically, you've got the right, the tenant has the right to quiet enjoyment, just in the way they do in a residential property, as on an AST. In other words, the landlord can't constantly harass them and come in without permission and all that sort of thing. They have the right to support and protection from the remainder of the building or the landlord's broader estate. So if they're just taking one, say 6 flats out of a block of 12, they'll have the right of support and protection from the rest of the building. And fundamentally, that's it. I mean, you can create a commercial lease verbally, just the same as you can create an AST. But you wouldn't really want to do that because the basic terms are actually not very extensive. You could probably put them on one side of A4. And if you allow a company to take occupation, give them the keys, give them possession, because don't forget, as a landlord, no matter what type of tenancy you grant, AST, company-led, commercial lease, you are giving up your right to enter or occupy that property completely. Completely. So they have total control of that property. So you don't really want that just to be left to the whim of a judge to decide who can do what, when, and how. You want it to be written down in a document. Yeah.
So it's really important to get it right, isn't it? And get it written
down. It is,
right?
because in the same way with any other contractual arrangement, the more detail, the better. Because if there's a dispute, you can go to the lease and you can say, well, okay, we disagree about this. This is what it says in the lease, so this is what we have to do. Easy. Whereas if it doesn't say it in the lease, then you're going, well, I think this, and I go, well, I think that. And these things do end up in court. Yeah. They do. And you don't want to go to court on a commercial lease, because it's not like the first tier property tribunal where the tribunal chairman's, practically making you a cup of tea, and it's very informal. It's a formal process. And you're probably going to need a barrister with you. I mean, we're talking expensive.
Yeah. So you need to get it right at the beginning, basically.
The better the lease at the beginning, the easier the relationship with the owner and the operator, company on the lease. Yeah, absolutely, definitely.
And when you're negotiating those heads of terms and coming up with those heads of terms, what advice would you have, Christine?
Well, it depends whether I'm talking to the operator or the landlord.
So a few tips for both then, perhaps.
Okay. All right. Well, yeah, I mean, some of the advice is the same for both of them, and quite broad. I mean, I've already said all the terms of the lease will impact on the rent. So the easier you make it as a landlord to increase your potential pool of leaseholders, the more income you're likely to generate. And the more restrictive you make it, the less income, because you're reducing your market. And for the operators, it is helpful to have the terms as broad as possible, even if it means you might pay a little bit more rent, because it just means you've got ultimate flexibility in your business. And this is your business, isn't it, as an operator? And you don't want to be hemmed in by lots of very intrusive sort of controls and checks and balances that are coming from the landlord. You want to have the right to freely occupy, without interference from the landlord, the property that you're paying rent for. If I was a tenant, acting for a tenant, I'd want break clauses, I'd want an Armageddon clause, I wouldn't want a guarantor if I could possibly get away with it. I'd want a nice, easy exit, either at the break clause at the expiry of the lease, no vacant possession requirement on a break clause. I'd want minimum dilapidations liability, etc. I'd want minimum repairing liability. If I was a landlord, I'd want exactly the opposite. So it is a balance. And yeah, both parties really are wanting opposite things, but actually in reality, where they come together in the middle and come to some properly mediated, and that's why most people employ agents to act for them, properly mediated agreement, then it's what they say about compromise. Everybody gets something that they want, and the things they're not getting are not the really important things that they're having to give up. The most important things they need, they're getting. And and as I say, this is why most people in companies, landlords, organizations employ agents, because they're very experienced in the market and they know what can be done and what can't be done. And they're very experienced in commercial leases. So they will tell their client, well, I know you want this, that, and the other, but actually you're never going to get that in a million years, so you might as well just forget it. Or that's not legally possible. That's another thing. Often landlords want things that are not legally possible. And I'll use the example of ASTs because it's easy. There's usually a clause in an AST that the tenant can't change the utility provider and can't change the locks, neither of which are legally enforceable at all. The tenant's perfectly free to change their utility provider and perfectly free to change the locks and to not allow the agent in. There might be a clause that says the agent's going to come and inspect once every 3 months, and the tenant just says, no, they're not coming in, that's it. The only time you can get in a property with an AST, if the tenant won't let you in, is with a court order. A commercial is a little bit different, because there'll probably be a clause in there that says the landlord has the right to inspect on reasonable notice, which is usually seen as like 48 hours, or you might be specified as a week. If you've got occupiers in there with particular sensitivities, say autistic teenagers, or whatever it is, then obviously you want to, as a tenant, you want to make sure that the landlord's right to inspect is carefully worded, so that it's not going to interfere with the operation, and it's not going to unbalance the atmosphere in the property and all those types of things. But on a commercial lease, there is normally the right to inspect, which can be enforced. So that's the difference between ASTs.
I guess it comes to the landlord and the providers understanding each other and trying to listen to each other and understand kind of the pressures on both of them and what's restricting each other, and trying to kind of come to that compromise, I guess, which is... That
doesn't just apply to leases though, does it?
No, I guess that's
that applies to absolutely everything in life. If only people would listen to the other side, try and understand their position and why they're taking it, and then understand why compromises need to be made, and then look at their own business plan, which is what that should be driving it, to see, well, could I make that compromise? Yes, I can. So let's just do it because it's important to them. So, you know, we're in a relationship now. The landlord and the leaseholder are in a relationship, and it's an important one for both parties. So it makes sense to make sure that it's harmonious, you know, in the same way to say, make sure you marry the right person, make sure you get the right tenant, make sure you get the right landlord. Yeah, it's not quite a marriage, because find you, some leases last longer than some marriages. So I know, but that's just an aside.
Thank you, Christine. That's great. It's been really good talking to you. We'll put your contact. We'll put your contact details in the show notes so people can, can track you down that way. And thank you. All right, take care.
No problem. Take care. Bye. Thanks, Lisa. Thank you. Lovely to talk to you.